Lots of questions come up, and to preface this, I am no expert in probates. I know my way around a little bit. I'm going to go over some top questions and just, I guess, a general overview of probate sales, whether you're on the listing or the buy side. So first, let's talk about what is a probate. Probate is the process completed when a descendant leaves assets to distribute, such as bank accounts, real estate, and financial investments. Probate is the general administration of a deceased person's will or the estate of a deceased person without a will. So when is a probate necessary? If the title holder has passed away, it is very likely the property will have to go through probate to be sold when the title was not held in a joint tenancy, title was not held in a trust, or there was no revocable transfer on death deed recorded. This is true even if there is a will. The client must decide in a consultation with their attorney whether the probate must be, or where the property must be probated. So, general description of how a sale of real property in probate works. So let's look at kind of what happens here. The estate administration provides for the orderly distribution of real personal property owned by a descendant. More specifically, any property which the descendant owned or in which the descendant had an interest at the time of death is collected into the estate and distributed to those entitled to it after all debts and expenses have been paid. The process of administering a descendant's estate is referred to as probate and is generally supervised by the probate court. A personal representative is a person or entity charged with the responsibility of administering a descendant's estate. A personal representative is either an executor or executrix, I'm sure you may have heard that term if you're getting licensed, who is named in a will, or an administrator or administratrix who is appointed by the court when there is no will, when the will does not name an executor, or when the named executor is unable or unwilling to serve. A personal representative is charged with the fiduciary responsibility of gathering the assets and paying the debts of the descendant in such a way that the beneficiaries or heirs of the descendant receive the maximum inheritance. The personal representative usually will hire an estate attorney to handle the legal aspects of the probate. Most business dealings are through the estate attorney. All right, so may the personal representative enter into a contract with a licensed real estate broker to sell real property? So we'll do kind of a somewhat of a Q&A type explanation as we go down. Yes, the personal representative may enter an exclusive right to sell contract with a broker for an original period of not more than 90 days, plus one or more extensions, each limited to the same time period. This real estate broker may cooperate with other brokers, may advertise the property on the MLS. So if you're going to take a probate listing, cannot be more than 90 days for the original listing term. Prior court approval must be obtained for each extension unless the personal representative is acting under IAEA. And I'll explain that in a minute. However, even here, if the personal representative has obtained only limited power rather than full power to administer the estate, the court supervision of the sale of real property is required. What is the IAEA? The California Independent Administration of Estates Act was enacted in 1987 to streamline the probate process by allowing the representative of a descendant's estate to take actions on behalf of the estate without prior court approval. So which CAR forms are legally necessary when taking a probate listing? Here are the recommended CAR forms. You're going to need your listing agreement of choice, which tends to be the RLA, the exclusive right to sell. Probate listing addendum and advisory. So that's form PLA. And that automatically attaches to the RLA, the listing agreement, if you check that box that this is a probate sale. I think that's a 2-pager. It's not that long. It's just a little addendum that goes along with it. The disclosure regarding real estate agency relationships, that's also attached in the excuse me, in the listing package. Fair housing and discrimination advisory, so FHDA and the PRBS are pre-checked, and those are also in that RLA package. The PLA guides the agent to comply with probate law by, among other things, limiting the initial listing period to 90 days. This rule applies to all probate listing agreements, even where the personal representative has authority under the IAEA. The PLA also caps commissions based upon the determination of a probate court or any other limit imposed by probate law. The PLA also indicates that the probate advisory, C.A.R form PA, is attached. This form lets the seller know exactly what the required disclosures are. So here is the PLA, the probate listing addendum and advisory. This one's just kind of generically filled out here. You can see that there's not a lot to this thing, but it does, it's notifying the property as part of the estate, or if checked, if it's one of these others, then that needs to be checked as well. Listing period shall be the shorter of 90 days or the length of time specified in the listing. So don't make your listings more than 90 days. And then it goes on to a couple other things. So that's what that form looks like. That's a pretty easy one to fill out. Additionally, to correctly set up the signature line and identify the seller, listing agent should complete the entity seller section of the RLA, located in the legally authorized signer paragraph on the last page of the listing agreement, just above the signature line. In the past, sellers used the representative capacity signature addendum, the RCSD, as an attachment to the RLA. However, the RLA has been updated to handle this requirement without the need of an additional form. So they basically incorporated the RCSD if you haven't looked at it. To use the entity seller section of RLA, do this. You want to check the box for entity sellers. Include the name of the legally authorized signer where indicated. The legally authorized signer is the representative. Next, include the name of the probate case and case number where indicated. Finally, the representative signs their name in the signature blocks and prints the name of the seller. So I did do an example of this if you want to see it, and I can post this into the Facebook group under the recording of this this session. So that way there, if you want to go back and review it, you can. In a probate, the seller's name is the estate of whatever the estate's name is. For example, the estate of Smith. The representative then prints their name where indicated beneath the seller's name and includes his title, administrator or tricks, or executor or tricks. By the terms of the listing agreement, whenever the representative signs or initials transaction documents, it is deemed to be in a representative capacity for the estate. So this is going to be the last page of the RLA where I checked the entity sellers box. This would have the authorized signer's name. I just typed in this instead. So if there's more than one, you put, first one here, second one here. This is the names of the legally authorized signers. And then the probate number, I just made up a number. Seller signature. So the printed name of the seller is the estate of Smith. And then the box is checked, printed name of legally authorized signer. So that's the first person. What their title is, we're just saying they're administratrix. And then their address, email, phone number, so on and so forth. Same thing with seller number 2. It's the estate of Smith. authorized signer number 2, what their title is, their address and information. And then of course you just put in our information as usual. So hopefully that helps you when you're signing these, so you know how it's set up. What is an administrator of estate? Administrator of estate is appointed by local court to oversee the estate administration process. They're responsible for contacting loved ones, paying debts, and distributing assets according to the deceased's will or state intestacy laws. Sorry, that's a tough one to say. The court will assign an administrator if the deceased didn't have a will, the will is deemed invalid, the will is successfully contested, there isn't an executor named in the will. While someone can volunteer to serve as an estate administrator, they can't act until the court approves them. If no one volunteers, the court will generally appoint a deceased next of kin, like their spouse or an adult child. So what's an administratrix? That is just the woman, a woman who is an administrator of an estate. It's kind of an outdated term, actually. What is the executor of the estate? Executor can be defined as a person or institution appointed by an individual to carry out the terms of that individual's will after death. Normally, people appoint executors in their wills. There can be one or more executors appointed. If no executor is appointed, but a person is named and given duties that an executor would be expected to carry out, that person can sometimes apply for probate as an executor according to tenor of the will. If a person who has not been appointed by executor intermeddles in the estate or acts as executor, he or she may be deemed the executor. That would be executrix if it was a female. Note the term personal representative is the current legal term used to refer to an executor or trix or administrator or trix and judicial trustee. So if you see personal representative, that is the same thing. That is how they're referring nowadays to these titles. Who signs a listing agreement? The personal representative who has been appointed by the court, typically either as the executor or administrator. This will require issuance of letters of testamentary. If a descendant's relative wants to sign a listing agreement, the agent should verify the relative's authority to do so. And you can do this by speaking with the attorney as well to confirm that you have the right person signing your listing agreements. On the listing agreement above the signature lines, check the box for entity sellers. We just went over this part. What is a maximum listing period for exclusive probate listings? Again, it is 90 days for the initial period, but it may be extended for an additional 90-day periods. You would need court confirmation for that. Such listings and extensions require court approval unless the personal representative has full authority under the Independent Administration of Estates Act. Shorter listing periods are okay, but the total listing period altogether cannot exceed 270 days. This question comes up a lot. What is the maximum commission permitted in a probate? Local courts, court rules vary, but this amount usually ranges between 5 and 6%, absent special circumstances. This amount can be determined by contacting the clerk of the probate court in the county in which the estate is being administered. So not necessarily where the property is. C.A.R's probate listing addendum caps commissions based on limits imposed by probate court or the California probate court. Judges retain discretion in probate court to set commissions as reasonable. How is a listing broker's commission established? The listing agreement usually specifies the amount of commission as a percentage of the sales price. The court will determine in its discretion what is a reasonable commission. However, the court may not approve an amount in excess of the maximum percentage established by local court rules. This amount can be determined by contacting the clerk of the probate court, the county in which the estate is being administered. Local court rules do vary. For example, Los Angeles County Superior Court limits commission to 5%, except in cases of vacant land. Orange County Superior Court limits commissions to 6% unless justified by exceptional circumstances. So you definitely want to check the county where the probate is being administered to determine what your commission can be if you're taking a probate listing. If a sale is confirmed by the court and subsequently closes, the listing broker has earned the commission specified in the listing contract not to exceed the maximum percentage allowed by local court rules. The commission also may not exceed the amount provided for in the listing contract. Example, if the maximum under local rules is 5% and the broker's listing contract specifies 4%, the broker is limited to 4% commission. So my suggestion would be to write in 6%, and that way there you're at least going to get the maximum. And if it happens to be less, then your listing agreement won't contradict what that is. On the flip side, if commission on the listing contract is 6% and the maximum under local rules is 5%, the listing broker's fee is limited to 5%. So ask for more. Can a real estate licensee receive a commission when buying estate real property as a principal? So can you buy this property in probate? Probate court specifically provides that the estate is not liable for any commission where the listing broker or agent is directly or indirectly the purchaser of the estate. In addition, the estate is not liable for commission when the selling broker or agent has any interest in the purchaser, so financial interest in the purchaser, or is the purchaser. So you might not earn a commission if you're going to be buying the property in probate as a licensee. What is broker's recourse when the court fails to award the broker a commission at the confirmation hearing? The broker's commission is not ordered on the court record or at the confirmation hearing. The broker may request it in writing and the court may modify the order to award a commission. If a licensee is present at the court, in court at the time of the hearing and fails to ask for a commission, or is not present in court and could have been, the court may choose not to modify the order. So make sure you're asking for the commission. You might want to show up to the hearing. How should offer be submitted on estate real property? Offers or bids on estate real property must be in writing. Nothing new there. Purchase contracts used for probate estate sale should indicate the title to be conveyed is whatever the estate holds. If applicable, the sale is subject to court confirmation. If applicable, the property is sold as is, and the total commission will be in the amount set by the court and will be paid only from the sale proceeds, whichever sum may be allowed by the court. To whom should the offer be submitted? So you're on the buyer side now, you have an offer, where do you send it? The offer received by the listing licensee should be submitted to the personal representatives or anyone else listed in the notice of sale as the appropriate recipient. Personal representatives will often designate the estate attorney as a recipient of offers for initial review. So if you're on the buyer side, submit it to the listing agent. If you are a listing agent, catch up with the attorney and see, if they're going to be handling the offers as they come in, or if you should be dealing with the personal representative or not. Who has the power to accept an offer concerning estate real property? The personal representative of the estate has the power to accept an offer. However, any acceptance is subject to court confirmation unless the sale is made under the IAE. IAEA Act, or the Act, by personal representation having full authority to administer the sale. And a couple more Q&As here. So when may offers be submitted on the sale of probate estate real property? Offers may be submitted anytime. An offer received by the listing broker at any time before a sale closes must be presented to the personal representative unless the personal representative has expressly instructed the broker not to present it, or unless the offer is patently frivolous. Whether the offer is patently frivolous depends on the facts of the circumstances at the time of the offer. The licensee's safest course of action is to submit all offers of this type to the personal representative for his or her own termination. So no different than if you're dealing with your regular buyer and seller that are not in probate. We have a duty to present all offers. Must a personal representative transferring estate property complete the TDS or provide other disclosures? I see this come up quite often too. Sellers of estate real property and mobile homes are exempt from the requirement of providing prospective buyers with a transfer disclosure statement, which is known as a TDS. This does not, however, relieve the seller from disclosing any known material facts regarding the value or desirability of the property. Sellers of estate property may use Form ESD, which is the exempt seller disclosure, to disclose any such known material facts. So instead of the TDS, you're going to be using the ESD, which is just a very, very condensed, shortened version of the disclosure, and they still need to fill that out. Is there a minimum price for which estate real property must be sold? Generally, yes. Without full authority under the IAEA, the minimum offer price for a private sale of real property must be at least 90% of the appraised value of the property. The appraisal must have been within 1 year prior to the date of the confirmation hearing. Is a licensee required to conduct a visual inspection of real estate? So here, Avid, yes, you are still required. It is a sale. It's a single family home, then you are required to conduct your visual inspection. A licensee involved in the transfer of residential 1 to 4 units, estate real property interest, including mobile homes, is required to conduct reasonably competent and diligent visual inspection of all accessible areas of the property to disclose to prospective buyers all facts materially affecting the value or desirability of the property. Although not required by the statute, the disclosure may be made in writing. Use the Avid form. That's just the recommended form from C.A.R to do your visual inspections. And I believe this is the last one. So are the price and terms prescribed by law when estate real property is being sold under the IAEA? No, under full authority to administer a descendant's estate, a sale of estate real property may be made at the price and terms determined by the personal representative. The sale is not subject to court supervision or overbid process. The law requiring the price of estate real property to be at least 90% of the appraised value does not apply to sales under the IAEA. So that is a question you need to ask the personal representative or even the attorney is this falling under the IAEA? However, the personal representative still has fiduciary duty to the beneficiaries and heirs of the descendant to maximize the estate's assets. Additionally, the sale can be for cash or on credit, meaning a loan. So if it's probate sale, it does not have to be a cash purchase. It can be, doesn't have to be. The purchasers can still obtain a loan. So I guess that's a nice condensed version of how probates work, and some of the more common questions, especially pertaining to listing terms, who's signing, and what can I charge. So I'll go ahead and put this document in the group, under the recording in the Facebook group. So look for it there. And if you need to come back and reference it, especially how to get your contract signed, your listing agreement. So you can always refer to it. Other than that, hopefully that sheds a little light on probates, the process, and some of the more common questions that come up. You can always give me a call. I am also going to put this in the online office in the probate section. There is already a probate training back there. It's a full course, actually. If you want to read it, it's in PDF format. If you ever need to reference, it's really informative. I recommend taking a little time one day, especially if you potentially have a probate sale coming up, to go in and just read that course. Probably take about an hour to read the whole thing, or at least skim through so you could get to the sections that answer the question that you have about probate. So other than that, hopefully everybody has a great week, and we will talk to you soon.